Welcome to Small Practice Support Information Session number 71. In this recording, Niamh Coonahan talks to Justin Purcell about the new Small Companies Administrative Rescue Process.
You're all very welcome to this information session. I'm joined by Niamh Coonahan from Madston, who's got the Business Law Committee in the Law Society, who's kindly joined us today to talk to us about the Small Company Rescue Process, otherwise known as SCARP, which was a bill brought through in June, but has yet to commence, if I'm correct. Is that correct, Niamh?
That's correct. Yeah. I mean, I don't have any guidance on when it's going to officially be signed into law. It was anticipated that it would be signed into law in kind of September, October. I am aware that the rules of the Superior Court, which will be adapted to take into account this process, are under review or being drafted. So it may well be when that's finalised, that the ministerial order to commence the legislation will be made. So look, in summary, this is what you'll hear referred to as examinership light, or it is effectively a rescue process that is available for SME companies. The aim was to provide an alternative to examinership, which is, I suppose, cheaper, more accessible, and capable of being brought to conclusion within a shorter time period. Look, there's a lot of upset generally, I think, in the business world as a result of the pandemic, and it's envisaged that, with government supports being, I suppose, decreasing, that a lot of companies will struggle to stay above the water, and that this is a process that might be availed of. So look, today I'm literally going to take you a whistle-stop tour through the different procedural steps to avail of the processes. I'll point out some of the advantages or disadvantages as I see them, and some of the specific powers and duties of a process advisor. As I see it, kind of our role as solicitors may be, for example, liaising or advising the company, directors or shareholders of the entity seeking to avail of the rescue process. It could be advising creditors, of any description, or employees as to how they might be impacted, or it could ultimately be to advise the process advisor. So this is the insolvency practitioner effectively who forms the rescue plan. I suppose the starting point is what companies are eligible to go in through the process. So it's a small or micro-sized company with an annual turnover of less than 12 million and a balance sheet not greater than 6 million. And for a small company, it must have a turnover of no greater than 700,000 and a balance sheet of no greater than 350,000 with no more than 10 employees. So the focus of the legislation is very much at the smaller company level. The other requirement, for example, the directors need to wish to avail of the process. They'll pass a resolution. Certain statutory measures or steps or conditions need to be met. So, for example, that the company is or is unlikely to be able to pay its debts. No resolution or order subsists for the winding up of the company, and no process advisor or examiner has been appointed for 5 years prior to the resolution to appoint the process advisor. So it's a kind of an opportunity you can use, for example, maybe once every in a 5-year period. Directors are required to make a full inquiry into the affairs of the company and to prepare a statement in relation to the assets and liabilities of the company. And that kind of underscores, for example, that statement is given to the process advisor, and then the process advisor reviews it, considers the affairs of the company, and then makes a decision in relation to whether the process advisor determines there's a reasonable prospect of survival of the company, essentially. So what will the process advisor take into consideration? He will review the statement of directors, the prospects for the business, so the prospects of success, the availability of funding. So although this is very much pitched as, a more available examinership process to SME companies, those companies availing of the process are still going to need to be able to figure out how to fund themselves through the rescue process and where the funding is going to come after that. And there can be a difficulty with smaller companies in terms of accessing funding. So that'll impact on whether there's going to be a success. So you really need to be thinking about, right, how are we going to fund this company during the process, and how does it exit the process successfully with a viable prospect of survival. Business plans, projections, again, and they'll be based on objective evidence. Could be just the wider economic situation. So for example, an impact to the industry as a whole, depending on what industry the company is operating in, other market considerations. So the process advisor, in making a determination, will I suppose, look at the company and the market within which it operates holistically to determine whether or not there is a reasonable prospect of survival. Assuming that the processor will meet the directors as well to make the determination, he must give his reasons in writing. So whether he thinks there's a reasonable prospect of survival or not, he meets with the directors, he prepares a report in relation to them, and he submits the report to the directors, who then have 10 days upon receipt of the report to consider the position and subsequently pass the resolution that the company should avail of this rescue process. It's at that point the time starts clocking to a certain extent for the 49 days for the rescue plan, because it's a very, very limited period of time, particularly in circumstances where the plan itself is required to be sent to all creditors and affected parties 7 days in advance of that. So basically, you have a rescue plan has to be formulated, agreed upon, and notified to everybody by day 42. That's a significant, I think, challenge in certain areas, depending on complexities. So if you're advising the process advisor, then the duties that he should be aware of, if you're advising directors, it's twofold. If you're advising the directors, you need to tell them that they have an obligation, for example, to the process advisor. And if they fail to disclose material information, that is a criminal offence, and that's specifically provided for in the Act. If they're notified that by the process advisor that the company doesn't have a reasonable prospect of survival, they have to take steps to protect the employee's interests, and they have a duty to cooperate on an ongoing basis with the process advisor. Then the powers of the process advisor. The process advisor has fairly wide-ranging powers. One particular power the process advisor has, for example, is to prevent acts likely to be to the detriment of the company or an interested party. So unlike examinership, where there's an automatic stay on enforcement, for example, or in taking certain action, that doesn't apply in the context of this regime. If the process advisor becomes aware of a certain action to be taken, he might need to apply to court for protection or to prevent that act being taken. There isn't an automatic stay. He can deal with charged property. There's provisions in relation to repudiating contracts. So they would be contracts, assuming there's something to be performed other than a pure monetary element. And he has the same rights in terms of a statutory order to supply information and to get cooperation. I don't know if there's anything other than specifically, he can convene, that the process advisor can convene meetings, is entitled to have notice of meetings, and to take whatever steps that, as I mentioned, that process advisor deems necessary to protect the company as such, or to prevent detrimental acts against the company. The duties then of the process advisor, I think the fundamental duty of a process advisor is at all times to keep the determination as to reasonable prospect of survival to the forefront of his mind. And I'll deal later on in the presentation with what the obligation is on the process advisor if he or she determines that there's no reasonable prospect of survival. So for as long as the process advisor continues in the role, the process advisor must at all times be satisfied that the company has a reasonable prospect of survival. At the outset of appointment, the process advisor will determine what is the appropriate court forum to deal with issues arising out of this particular rescue plan. The legislation prescribes that this should be a cost-effective procedure in effect, and that the process advisor has to take that into account in determining the appropriate court involvement. And there's definitely a push towards the circuit court in the location of the company's registered office with a view to keeping costs down. My own view in relation to that would it will depend on the nature of the issues that arise as to whether that will actually work out as being efficient. For example, if you're dealing with examinership where there would be similar issues, you are generally assigned a judge who's a specialist in the particular area, and that can certainly speed up the legal process in some respects. The process advisor has duties in relation to emails, giving notice. So for example, on appointment, the process advisor has to publicly announce his or her appointment in the company's registration office. The process advisor also has a role in the context of excludable debts. So for example, excludable debts are generally Revenue Commissioner debts, for example, or debts that arise in the context, for example, of employees or other welfare payments. And I'll talk about those a little bit later on. And he also has a duty to give notice to employees and creditors. So notices in relation to meetings to be convened for the purposes of considering the rescue plan, but also notices to them in circumstances where he determines that there's no reasonable prospect of survival if the plan fails, for example, or he doesn't believe it's going to be successful. Then in terms of, I suppose, just the requirements, as I mentioned, requirement to give certain information. If there are excludable debts, there's a requirement. So if, for example, a creditor doesn't want to be treated as part of the rescue plan, there's an obligation to notify the process advisor of the intention to opt out of the rescue plan. There are certain requirements in relation to repudiation, and as mentioned then, there's no automatic stay on proceedings. So the rescue plan itself, it should be prepared as soon as possible after appointment. And it contains, again, if you're familiar with the examinership process, it's not too dissimilar to what will be contained in the rescue plan as part of an examinership process. So you specify each class of member and creditor. And for example, creditors and members within a class should be treated equivalently unless they agree to be treated otherwise. So for example, you treat everybody within the class the same. You specify any class of member or creditors whose interests or claims will be impaired by the rescue plan. So for example, a creditor who receives less than the amount he's due is a creditor who would be impaired by virtue of the plan. You provide, as I mentioned, equal treatment. And if there are any changes that require to be made to the constitutional documents of the company, they need to be specified in the rescue plan. So for example, if there's changes to the shareholding makeup or the structure or the different types of classes or variation of rights that attach to shares, for example, that needs to be documented as part of the rescue plan. And whether there's any changes that should be made in relation to the management or direction of the company. So for example, it may be in circumstances, if there was no separate financial officer, that might be something that the process advisor might recommend should be addressed on a go forward basis. And to the extent appropriate then, the rescue plan should also include any excludable debt where an objection has not been submitted within the timeframe and any necessary provision then for repudiating a contract. So the rescue plan should effectively deal with everything to ensure, I suppose, the future financial viability or success of the company. And it's important to know it shouldn't provide for a reduction in rent reserved under a lease or land or extinguishment of the right for lesser to any such payments. That said, it may be possible outside of the actual rescue plan itself to reach kind of a separate agreement as between the parties. Then the rescue plan, again, very, very tight time frame in my view to do this in circumstances where you have a longer period for an examinership. So the process advisor has to convene meetings of the members and creditors within 49 days of his appointment. And day one, as mentioned, kicks in when the directors pass the resolution to appoint the process advisor. So that means actually, because creditors are required or members are required to get 7 days notice in writing in advance of the meeting, it means your plan has to be put together, finalized and sent out by day 42. And I think, look, that's it can be a fairly tall order to achieve. It can be a challenge in examinership to do that within, a much longer period. In terms of, I suppose, voting, for a class to approve the rescue plan, it has to be approved by 60% in number, but also representing a majority in value of at least one class of impaired creditor. So you have to have the plan approved by at least one impaired class before it can go forward. Once the process advisor has held the meetings, the process advisor prepares a report. I'm not going to call out everything that's on screen because Justin will share the slides with you towards the end of the week, but it deals with the content of the process advisor report. Again, not too dissimilar to the examiner's report, and all prescribed by the legislation in question. So it's quite an easy follow through. There's a heading and the requirement to be set out in the report. So who or what are the objections then to the rescue plan? The process, I suppose, the rescue plan, the starting point really is the rescue plan will become binding 21 days after filing the notice of approval with the court. So for example, the process advisor prepares his report and files the notice of approval with the court, unless there's an objection by a member or a creditor. So the plan, the rescue plan, if you think this through, assuming nobody objects to the rescue plan, it will become binding within 70 days. So 70 days from that first resolution that's passed by the directors. If any creditor or member has previously voted to accept the plan, they're precluded from objecting unless certain circumstances pertain. So for example, if their acceptance was obtained improperly, if they became aware of an improper purpose or something that wasn't brought to their attention earlier, for example, and there are limitations on grounds for objection and for repudiation. So the types of, I suppose, objections, or how do you object? The types of objections, first of all, might be that for somebody who didn't vote in favor of the rescue plan, that it unfairly prejudices the interests of the objector. So for example, if a particular creditor was treated differently to other creditors within a class, for example, that it was inequitable, that there was some material irregularity with the meetings. So say, for example, the meetings were convened, but the relevant statutory requirements to send the rescue plan in advance wasn't sent out, or something to that effect. Somebody hadn't received notice and there was no material prejudice suffered as a consequence of not having received notice. Or that, for example, it's not necessary, or it's not going to facilitate maybe the survival of the company, or something to that effect. If somebody voted in favor of the rescue plan, they really can't object unless there's some level of impropriety. And like I suppose, look, the process is quite prescriptive in terms of the legislation. It specifies the basis upon which it can be objected to, and then the court will hear the matter and determine whether or not, for example, the decision, or whether or not the rescue plan is binding as it's proposed, or whether any modification is required to be made to the rescue plan. And if not, then the court can, for example, make a winding up order if the objection is upheld. But that order can't be made by the circuit court. It's only in the High Court that order can be made, and that's to do with other aspects of the Act. So I think it's not unusual that if for whatever reason the rescue plan fails, that it's going to end up in a situation where the company ends up in liquidation, particularly where it comes before court, because the very starting point to all of this process is that the company itself is or is unlikely to be able to pay its debt. So it is in the insolvency space as it stands. So I spoke to you earlier about the process advisor's duties. If the process advisor became aware or determined at any stage through the process that the company would be unable to be rescued, so where there was no reasonable prospect of survival. Once the process advisor becomes aware of that and determines actually the reasonable prospect of survival test can no longer be satisfied, he's obliged as soon as practicable after that to notify effectively or prepare a report. He lets the directors know, he sends a notice to the employee members, creditors and revenue. The report needs to contain reasons as to why he can't prepare the rescue plan and the recommendations or his next steps. Now, those recommendations aren't binding. It can include winding up, and those recommendations can also be considered in the context, for example, of if the directors choose, notwithstanding that report, to continue to trade the company, it could impact on them in the context of, say, for example, reckless and fraudulent trading. So while there's no obligation to take steps to put the company into liquidation, there could be other issues for the directors, or they could be exposed in other respects. So cost, expenses, and remuneration, I think, look, this is just generally important from our perspective to whether it's we as advisors or advising just generally other creditors. The process advisor, when he accepts or produces his initial report as to the reasonable prospect of survival, the process advisor is also required to disclose, for example, the potential costs and fees. Now, you would expect as well that the process advisor will need legal advice, and that'll be catered for example, in this report. He'll determine what is the relevant choice of court, costs and expenses. So, for example, when it comes to sending notices of the meetings, the process advisor, to the extent that he can do, should, for example, consider whether it's possible to engage with the companies. So whether those notices, for example, to use those resources rather than his own, with a view to minimizing costs. Where the process advisor's report, like the report after consideration of the rescue plan, again, should take into account the costs and expenses incurred to date. You would expect the process advisor's costs and expenses to have been taken into consideration in the context of formulating the rescue plan, for example. If, and this comes up in examinership, it comes up in liquidation as well, to the extent that the process advisor uses his own resources. So, for example, whether it's his juniors in the accountancy practice or whatever it is he uses for the purposes of sending out the notices or other support, he may not be able, or she might not be able, to recover fees in circumstances where, for example, the staff or the infrastructure or the support of the company could have been used with a view to defraying the costs. Creditors, if they're not happy with the level of fees, costs, and expenses, by the way, they would include, for example, legal fees. If they're not happy with them, they can request the court to review the costs and expenses and remuneration. And I think in considering that, the court is likely to have regard to the case law in relation to liquidations and examinerships generally, in the context of considering what is an appropriate level of fees, costs, and expenses. And any of those costs and expenses that are paid in full, that have been confirmed, for example, are paid ahead of any other claim, secured or unsecured. So look, it's just to have at the back of your mind, there are requirements that need to be met on an ongoing basis throughout the rescue plan. Now, I'm conscious, I suppose, look, one of the things just to bring home or to consider is the differences between the examinership process and the rescue process. Because if you're faced with a situation where you're trying to advise, I expect in a number of instances, we will have to give both options to our clients, with the advantages and disadvantages potentially of both. And it'll have to be carefully assessed to see what's the best option from our client perspective, the client being the company, for example. So the principal differences then are, there's no size restriction in examinership. So there will be certain companies, for example, that can't avail of this small firms rescue process. That said, there's no reason why a small firm can't avail of an examinership process, and it may be appropriate depending on the circumstances or the complexities of the situation. The whole point about the rescue process is it's initiated without court involvement, with a view to reducing kind of, I suppose, the costs involved in it. So the rescue process is initiated by means of the directors passing a resolution to appoint the process advisor, whereas examinership is initiated by way of court petition. And again, then it's the process advisor that determines the prospect of survival or the prospect of success, whereas in examinership it's determined by the court. We've spoken about the time period, so much shortened time period in the context of the rescue process, and there's no automatic stay. They're the principal differences. I'm happy to deal with whatever questions maybe that you might have, and I think there's a couple maybe in the chat function. Is there already?
If anyone would like to ask a question, we'll just take it on the chat there. Maybe you've given us a wonderful sort of just overview in what is quite a an intricate situation without any case history so far. So for people joining the call late, this is a new bill, and there hasn't been any case law history to sort of enlighten us. So there's a little bit of moving around in the dark. So the main question I have, and it may be a repeat of what you said, is like, where's the opportunity for solicitors in this, do you think?
I think the opportunity for solicitors, it is advising the company itself, maybe individual directors. So for example, it may come to you in circumstances where a director is worried about, reckless and fraudulent trading, companies in financial difficulty, they don't know where to go. They may be encountering severe difficulties with a particular creditor, for example. They need to know what their options are. So their options might be, this is just one of a number of options in addition to liquidation, potentially examinership, ceasing to trade, for example, what other steps they might take. And there's also opportunity, for example, to advise the process advisor, and I think individual creditors or employees who could be affected by the process. So I think there's lots of opportunities for us as a profession to provide our support. I mean, I know, Justin, you mentioned we've no, I suppose, case law in relation to rescue plans, and we don't, but because it's so similar, I think, to examinership, I think that there's a lot of knowledge out there that would apply by way of analogy. So if you come across a particular issue in the context of rescue plan, it's likely that the case on examinership will point you in the right direction.
So just a question there around the rescue plan itself. Like the time period is very short. And so is there opportunities to extend that rescue process, or is it a very fixed time period?
There isn't, it's a fixed process. Yeah.
And so then is there opportunity for creditors potentially to frustrate that process by?
Well, I suppose, look, in any, if you're dealing with, particular creditors that might be tricky, there is an opportunity to prevent, to, for example, frustrate the process. So, for example, whether that's, for example, the creditor seeking to take preemptive action to stop you taking this step, whether it is referring the matter to court on a particular point, objecting, for example, to the rescue plan itself. I think, that there potentially is, in all instances. And I think that's where, as a process advisor, and that's where I suppose, look, there has to be open communication to a certain extent between the directors and the process advisor, because the process advisor ultimately has the power to apply to court, for example, to stay proceedings, or, for example, for certain orders in relation to charge property or things like that. So look, I think, I don't think you can, you probably, all of the situations that arise in examinership would probably arise here in the context of rescue plans as well. And I think this is where, from the point of view of the creditor, the position would have to be, look, the alternative here is liquidation, and you'll fare far worse in a liquidation than you will through the rescue plan or through this process.
So I know we're coming up to about 28 minutes past. We have final 2 minutes. If anyone wants to ask a question, I have a question around enforcement, and which court does this go to enforce whatever may arise?
The only court that can make a winding up order is the High Court, but the process advisor determines at the outset following his appointment which is the appropriate forum. And but it's very much pushed in the case of going towards the local circuit court with a view to reducing the costs. I have a doubt myself as to whether that does actually reduce the costs, but it remains to be seen how it plays out.
Is there a way of getting, I know you said there's no extension to it, but squeezing some extra time for the company, because it's all front loaded, so they have to have their rescue plan kind of in place. They need to have their figures.
Yeah, there isn't a way of squeezing extra time from a statutory perspective as such, but I think this is about having a lot of the preparatory work done in advance.
So you can delay the starting of the clock.
But potentially, now, whether they can or they can't depends on the circumstances, because if they're continuing to accrue debts in the meantime, the directors may be they may be concerned as to their personal position, for example, in the context of personal liability, etc. So I think there's a lot of having all of your affairs in order, for example, having everything together for the process advisor to speed up the process. Some people on the call might be familiar with the concept of pre-pack examinerships. So these would have been situations where a lot of the groundwork may have been done with creditors in advance, or certain creditors, for example. So you knew that you might have agreement in principle, and you don't trigger the start of the rescue process until some of that is done. The reason being is, even for larger companies, the examinership process itself can be quite a shortened time period, depending on the nature of the companies, and there's good and bad for that. So yeah, I think you can, given the short time frame, and depending on the situations, you can certainly do a lot of work in advance. And this is where, look, most companies some referrals will come through, for example, accountants and auditors, for example. A lot of the prep work, I imagine, would be done in advance.
Very good. Listen, Niamh, you're brilliant. We're just out of time. We've covered a large piece of work in progress, I guess, and we'll see over the coming months what happens. Next week, we're joined by Gavin Richardson, who's going to talk to us about case management and some changes to Superior Court rules that have come out. So you're all very welcome, or thank you very much for joining the call today. Thanks, Niamh, for being such a good sport. Slán.
Bye. Hopefully